Yes, sir. Please turn on your screen also.
What's going on? Hold on, I'm trying to do that here. I'm not seeing it. There we go.
There you go, sir.
This is Eric, capital E, lowercase R-I-C, capital M, lowercase A-R-T-I-N, living man, hereby threatened arrest, and appearing by special appearance under general jurisdiction granting.
Thank you, sir. This matter is scheduled for a pretrial today. I received a letter from Mr. Martin that was forwarded to the prosecutor's office indicating that he was not able to open the discovery that was provided to him, and requesting that he get another copy so that he could try to get it to work. He indicated that he had tried to go to the library in order to get it to work with no success also. And since that time, Ms. McDuffie, were you able to provide him with another copy?
No, Your Honor, we have not provided another copy. So the issue, I think, is that Mr. Martin, first of all, let me just confirm that when discovery was demanded and ordered at the October 26th final settlement conference, obviously he received it. He picked that up on November 7th. That contained a flash drive with the media, which is MSP WatchGuard video, a copy of the police report, and a copy of the citation itself. So Mr. Martin has received everything that we would provide to any other attorney, except that it's not a link because he didn't give us an email and he wanted it mailed to him. But what often happens is that to be able to view that, you need to possibly install a player on your local computer so that you can, play that video. And if Mr. Martin is going to the library, it's most likely a system that's not going to allow him those types of permissions to do that. So I would encourage that we don't really have, it's not an issue, I don't believe, with what he was sent having some sort of error on it, but I think that he should connect with his standby counsel because the PD's office would likely be able to assist him in viewing that.
Thank you, Mr. Martin. So what she's saying is you have to install a particular application called a player to be able to play that. It's not going to just play on its own. You have to have the downloaded app or whatever it is that you need to play it from that. Download it to your actual computer. When I was a defense attorney, the way we had to do it is to download that player as well. That's the way the process works, sir.
So I don't know. I don't understand how to do that. And I object to her saying it's not nothing they sent. It shouldn't be this complicated. It should just be able to review it.
Well, that's how it works for everybody, you and every other attorney, sir. So what she's suggesting that you do is to get with Ms. White, who is your standby counsel, and have her assist you with downloading that so you can review it, sir.
Well, as I objected to before, I don't accept no attorneys because then that would give unlawful, fraudulent presumptions, and I'm a defendant, and along with a lot of other presumptions, which I'm going to be sending affidavit to rebut 12 of the general fraudulent presumptions that's done in cases. Haven't did it yet, but yeah, that's the problem with that.
Well, that is your choice, but that is the mechanism for you to review it. You can utilize what is available to you or you cannot, but those are your choices. I'm going to give you one more chance to figure out how to get that done. If it's not done at the next pretrial, then we'll just keep moving forward. Okay?
Well, no, I object to it. Well, I need to be able to.
You can object to whatever you want to object to, sir, but that is what we're doing today. pretrial in this particular matter is going to be adjourned to February 1st, 2024 at 9:00 a.m. We will see you then.
So hold on, let me write this down. But February 1st,
Correct?
at what time?
At 9:00 a.m.
9:00 a.m. Okay, now this lady you're talking about, what is her name again? I don't have her number or nothing.
Miss
Sandra, I'm sorry,
there you go.
Sandra White. It's on the screen there. Can you see it?
Yeah, I see the name, but I don't see no number or nothing, and
Okay, will you answer our calls? I'm gonna give you the phone number. You ready? I'm
yeah.
gonna give you my office number. Okay,
I just wanted to well, I shouldn't object again to her representing me, because like I said, I'm always of the position to present myself as a living man, so I'm not gonna give up my right to do that. But but I will contact her if you guys are gonna force me, so to say. It's only gonna be, it's by force, and not give me no other option to review the video myself, due to them not sending something that can be reviewed. But that's all I got to say on that. Like I said, it'll be by force. It's not they're not giving me no other option. So
All right. Thank you, sir. Your objections are noted, and I'll see you back here on February 1st at 9:00 a.m. Okay?
okay,
Thank you. Take care of yourself, sir.
I will. You too.
Bye-bye.
Bye bye.
Bond is continued. The court will call the case of the state of Michigan. The case is State of Michigan versus Castilian Cotton, case numbers 19F00535, as well as 22F00428.
Rachel McDuffie for the people.
Castellion Cotton.
Thank you so very much. All right, these PD cases, who's
I'm sorry, Assistant Public Defender Sandra White on behalf of Castillo Cotton.
All right, we're supposed to be here for sentencing in one case and both cases, I guess. And Mr. Cotton did not make and keep his probation appointment.
I did. I've been going to my community service thing, dropping everything. I didn't know anything.
Sir, do you hear me calling you?
Ma'am,
I said probation appointment. I did not say anything about community corrections.
I thought that's where it was, ma'am. I didn't know I had to go anywhere different. I've been reporting every week. I've been going there dropping every week. You can ask them. I have to go there today at Thursday. I've been dropping in everything, doing everything that you told me to do, Ms. Washington. I did not know I thought I was supposed to go to community services, man.
You're done talking?
Yes, ma'am.
When you were entering your plea, after you got done, I gave you a phone number and told you to call them within 24 hours by the next day at 9:00 a.m. in order to schedule a time to have your pre-sentence investigation report done. I tell everyone that after their sentence.
Your Honor, when I went back to go report, they switched me to a miss.
Sir, are you even what
some
I'm
of it-
saying? You see, you talk. You're just talking. You're not listening. Did you hear what I just said?
Yes, ma'am. I heard what you said. I must have
Who did I
misunderstood.
say to call? Who did I say to call?
Yeah, I thought you said community service.
Who did I
was
just tell you to call?
probation officer, man.
Okay. All right. So do you understand that now?
Yes, ma'am.
Okay. Who are you gonna call?
My probation officer, man.
All right. Do you have a pen to write down the phone number?
Can I have a pen? 1 second, ma'am.
All right, we're gonna print out a notice with it on there for you. Okay, so you need to stay here in the,
No. No problem.
and see, you're talking to me again. You need to stay here in the courthouse and we're gonna take that piece of paper out to you before you leave, okay?
Yes, ma'am.
All right.
Thank you. Sign the card. Might be here.
All right, I'm gonna reschedule the sentence in this case to January 11th, 2024 at 10 o'clock a.m. You need to call probation tomorrow after 9 o'clock to schedule the appointment to have your pre-sentence investigation report done, okay?
Yes, ma'am.
All right. You're gonna owe the court an additional $60 re-referral fee. This will be your last time to
Yes,
get,
ma'am.
if you don't get it done, then the next step is to put you in jail so we can get it done that way, okay?
Yes, ma'am.
Thank you, sir.
Thank you. I gotta wait till some paper. Yep.